Second, this is a dedication shiur, a very, very important one. Okay. This particular shiur is done. It's the Yahrzeit of Jeffrey Kaplan. So Yehoshua ben Avraham, and I just want to wish long life to Margaret and his children. And Jeff was a very, very special person. Just put yourself on mute a second. All right. Thank you.
He is.
All right, he has. Now, by the way, Arthur is doing wonderful work with palliative care and geriatric care. So obviously he's coming to join the shiur with his work at the hospital at the moment. And Jeffrey Kaplan, I just want to speak about him for a minute or two, Kevin, before you get started. This is very important, is that I owe both Jeff and Margaret a huge amount of gratitude. In the decade or so I've been living in Carisbrook Street, the Kaplans have always opened up their home to me. And Jeff has always been a wonderful friend to me. And obviously Margaret, but we're talking now specifically about Jeff, because please God may live to be 120. And I miss him. He loved Trump. I think every week he'd do a parsha and he'd give me an update in terms of what Trump was doing and the Republicans, etc. That's the only thing of it, is I think he would have been absolutely mortified had he still been around to see what Biden's done to the country. But I hope many of the ideas that sometimes I give over in the shiur, when I think of it, I mention it in Jeffrey's name. But the Shulchan Aruch, he would often teach me from that, which was the halachot, which the Mishnah Berurah is based on. And Jeff was able to, with his Gemara skills, show me where the halacha was derived in the actual Gemara of how we paskin today. So he was unbelievable. So Kevin, if you'd kindly just teach us before we go into the Gemara shiur.
Yes, but actually starting a new chapter. It's called The Person of Integrity. So I'm sure it definitely applied to Jeff. I'm quite sure it did, as Damon can attest. Okay. So the word yashar, which is mentioned frequently in the Tanakh, is actually a Hebrew word for straight, direction and behavior. Yashar literally means straight, but its connotation changes in various contexts. The most common meaning of the word are forthright, honest, just, decent, and upright. In this chapter, we'll address the following: the requirement that people be straight and behave with integrity. 2, the meaning of straight as it relates to righteous and upright is he. That's from Devarim chapter 32, verse 4. And 3, the definition of the attribute of straight as it relates to moral decisions. Okay, the Torah uses the word yashar as related to human behavior in 3 places. In Shmot, it is written, if you hearken diligently to the voice of Hashem your God and do what is just, yashar, in his eyes, then any of the diseases that I brought upon Egypt, I will not bring upon you, for I am Hashem your healer. And just one or two more paragraphs. In Devarim chapter 6, verse 18, it is written, you shall do what is fair. And then it says yashar as well in brackets. Fair and good in the eyes of Hashem, so that it will be good for you. And another quote from Devarim chapter 12, safeguard and hearken to all these words that I command you, in order that it will be well with you and your children after you forever, when you do what is good and right in the eyes of Hashem, your God. And lastly, in all of the aforementioned citations, reward is promised for being yashar, a term that means nebulous. In explaining the verse in Devarim chapter 12, verse 28, what is good and right in the eyes of your God? Rashi writes, good in the eyes of heaven, right in the eyes of men. According to Rashi, the word good refers to fulfillment of religious mitzvahs, whereas yashar refers to interpersonal mitzvahs, to act properly towards another person. Okay. So in Hebrew, and If someone is dishonest, you say lo yashar. And if you're going to go straight, you say the direction. So you say yashar ad. Then they say smola, which is left, or yamina, which is right. So it's used. Well, yashar is, I suppose you could use the word, could be to have a straight direction in life as well. I just actually thought of it now. Okay. So anyway, so Damon, are you going to send this link to the Kaplans?
Yeah, I mean, I'm going to send it to the Kaplans. I know the word Yisrael means the straight ones of Hashem. Actually, if you look at the root of the letters, because
you got the word yashar in that word.
Yeah, yashar kel, the straight ones of Hashem. Correct.
Ah, okay.
So what I was going to do is the word Mishnah and the Shoma have the same Hebrew letters. So on a Yahrzeit, it's appropriate to read that. And since we've got a Mishnah now before the Gemara, and Gavin was the only one of both of you, I think, that knew Jeff better, I'd like it if Gavin can read the Mishnah. I'm just going to share the screen. If you could just give me 1 second, guys. Gavin, if you'd kindly read it, since you knew Jeff quite well too.
And also a massive Trump supporter. So,
yeah, you both had Trump supporting in common, but I must tell you something. Jeff was one of the most honest people I met. He hated shenanigans or dishonest behavior. He was absolutely straight. So, Kevin, it was totally appropriate. I couldn't have thought of anything better to say.
Gee, yeah.
Would you like
fortuitous?
Fortuitous, yeah. Absolutely. Would you like to read the Mishnah, Jeff?
Thank you. If he stole the animal in the owner's domain and slaughtered or sold it outside the owner's domain, or if he stole the animal outside the owner's domain and slaughtered or sold it in the owner's domain, or if he stole and slaughtered or sold the animal outside the owner's domain, he pays the fourfold or fivefold payment. But if he stole and slaughtered or sold the animal in the owner's domain, he is exempt. The Mishnah continues. Excuse me. If the thief found the animal in the owner's domain and was in the process of putting it out when he died, while still in the owner's domain, he is exempt. If, however, he lifted it while it was still in the owner's domain, or he took it out of the owner's domain and then he died after he had performed the kinyan upon it, he is liable. The Mishnah continues. If he gave it to a kohen for the redemption of his firstborn son, or to a creditor, to an unpaid shomer, to a borrower, to a paid shomer, or to a renter, and he was in the process of putting the animal out of the owner's domain and he died while still in the owner's domain, he is exempt. If, however, he lifted it while he's still in the owner's domain, or he took it out of the owner's domain and then he died after he had performed the kinyan upon it, he is liable.
Excellently read, Gavin. Excellent. So, one of the issues, there are a few issues that's going to come up in the Gemara, which I'm about to teach about this Mishnah. One of the issues is that in order for the thief to be liable for the theft itself, the twofold payment, because the pasuk says, and he shall pay double, he has to obviously acquire the animal somewhat. In other words, just like that acquisition of buying and selling, the thief has to acquire it. Otherwise, what has he stolen? In order to be eligible for a 4 or 5-fold payment, if he stole a sheep or an ox, then in that particular case, there also is a consideration of acquisition. So what's one of the ways to acquire it is to change the domain. So even if you have a look at the laws of breaking or keeping Shabbat, if you carry from a public domain to a private or from a private to a public, that's a malocha that is transgressed on Shabbat. It's the same thing about taking it from the original owner's domain to a case of either the thief's domain or a party at which he sold it to. Either way, you're dealing with the same sort of issue of creating a acquisition. So an acquisition is a kinyan, And when we talk about a kinyan, there are different ways to acquire. As you know, one of the ways to acquire is to do mashicha, which is to pull the animal. You're drawing it towards you. So if you're drawing the stolen animal towards you out of the original owner's property into your property, or certainly into the public domain, that's considered an acquisition. Now, there's two types of acquisition. The one is permissible acquisition, at which there's an agreement by both parties, and there's an act of theft, where you acquire it illegally. You also have a third definition, and that is if a shomer, a guardian, you've given it to him to look after, and he claims, and you say to him, I'd like my ox back, I'm back from Australia. He says to you, what ox? He plays dumb. And that is fraud. That's another act of acquisition, but it's also illegal, like theft, but it started off on a legal basis. Or you pay somebody a deposit where they're going to do goods and services, and they abscond or they don't fulfill their obligations. So that's one form of a kinyan, is with an animal, mashicha, to pull it towards you. Another kinyan is obviously with regards to a star, a document, transfer of money, etc., to witnesses, aidim, that sort of thing. So there are various ways to do an acquisition. Okay, so let's begin the Gemara at this particular point. So the Gemara cites an inquiry in which our Mishnah is brought as a proof. Amimar inquired, did the sages institute pulling mashicha as a method of acquisition with respect to shomrim or not? So shomrim are guardians. So we say, is mashicha a method whereby the guardian acquires it with the permission of the owner or not? Is that valid? So basically, under biblical law, a sale of movables is effected when the buyer pays for it, even if he doesn't take physical possession. So the rabbis, however, were concerned that if the acquisition were to take effect while the merchandise remained in the possession of the seller wouldn't make any effort whatsoever to protect the merchandise in the event of a fire or a robbery. And if the fire were to break out in the place where the merchandise is stored, he wouldn't do anything because he got his end of it out of it. He got the money. So therefore, the rabbis took the biblical contract one step further, and they instituted that a sale of goods or services should not take effect at the time that the merchandise is paid for, in the case when there's merchandise, but only when the buyer takes physical possession of the merchandise by performing mashicha. In other words, he's pulling the merchandise out of the seller's possession into his possession. So we're not just talking about livestock here. So when I went the other day to Hi-Fi Corporation to buy a cell phone, I took it out of their possession into my possession, into the car. So what does that have to do with a shomer guardian? Is we saying here that the reason doesn't apply with respect to a guardian who takes movables from the owner for safekeeping, or perhaps somebody that's renting it, the article from, he's renting maybe scaffolding or a lawn mower or whatever the case may be from a company, or somebody that borrows it. If, say, for example, a friend of mine doesn't have a car and he needs a car in order to do something, and I lend him a car, in that case, that law doesn't apply. So Amima therefore inquired whether the sages instituted mashicha, the pulling for a sale, that they did so only with respect to a sale. In other words, when the reason for the enactment is applicable. Or he's asking, maybe it also applies to the four shomrim, which is the unpaid custodian, the paid custodian, the borrower, and the renter. Now, we said, as far as the laws of custodians are concerned, the more of a favor that person is doing you, the less you've got to make them obligated. So, for example, you're about to leave overseas and you want someone to look after your house and feed your dogs and look after your things. But you planned it to the last second. you can't have him responsible for anything other than the basic theft, etc. Because if you make him responsible for a myriad of factors, the problem is he's going to say, listen, I need to be sued like a hole in the head. Go get somebody else to look after your home and your dogs. But if somebody's borrowing goods from you on the other side of the spectrum, okay, and you're lending it to them, you're doing them a massive favor. And since you're doing them the majority of the favor, they have to be liable for much more than just when somebody's doing you a favor. There are negligence issues, there's issues of misuse of equipment, etc., etc. And then you've got this case where there's a paid custodian, where the guy is charging for a service of looking after your stuff. So therefore, with the paid custodian, who's doing whom the favor? So, I mean, that we've dealt with before, etc. But the bottom line is, if they did institute it with respect to a shomer, a guardian, the shomer does not become liable for the animal's safekeeping until he pulls it out of the owner's possession into his possession. So if they didn't institute that with respect to a guardian, then the guardian becomes liable for the animal's safekeeping as soon as he agrees to serve as a shomer over it. So that's a bit of a problem. So it's there just to suit both parties. So that's the answer to that particular question. Now, the Gemara offers a resolution because he don't quite know if it holds by all opinions. So Rav Yirmiyah said, come learn a proof from our Mishnah. If he gave it to a coin for the redemption of his firstborn son, to his creditor, to an unpaid shomer, or to a borrower, or to a paid shomer, or to a renter, and he was basically the thief. When we say the thief was in the process of pulling the animal out of the owner's domain, and it died while still in the owner's domain, the thief is exempt. Because if it died after he pulled it out of the owner's domain, at that point the thief is liable, but not while it's still in the original owner's domain. Okay? Now, does not the Mishnah mean that the shomer pulled it out upon the instruction of the thief? Okay? So we're saying, is he acting as an agent, and therefore the shomer is liable? And therefore he rendered the thief liable for the act committed on his behalf. Because we said, as far as thievery is concerned, generally there's a law that there can be no agent through transgression. But as far as that's concerned, we said, just like there's a juxtaposition in the Gemara between if a thief steals an item and he slaughters or sells it, just like if you want to sell it, you need a buyer. So to here, the shomer can have the thief can have an agent, and that agent doesn't assume full responsibility for himself, but the thief is also working in partnership with that agent. Generally, when an agent acts and commits a sin, the agent is responsible because the person that asked him to commit the sin could have said that he never committed the sin directly. It's b'shoigeg, indirect, and as well as that, the person knows what is the right thing to do or not, so he has to take responsibility. So it says, now does not the Mishnah mean that the shomer pulled it out upon the instruction of the thief, and therefore rendered the thief liable for the act committed on his behalf? So the Gemara says, you must learn from this Mishnah that they instituted pulling Mashiach as a method of acquisition with respect to shomrim. Meaning that if we say that Mashiach was not instituted with respect to a guardian, a shomer, the shomer's pulling of the animal out of the owner's domain would not constitute an act of kinyan, of acquisition, since the shomer had no intent to perform a kinyan on the animal. So we don't hold the thief liable for having performed an act of theft, a kinyan mashiach, through his agent. Okay? So we're saying there that clearly the shomer is liable, because that very act of pulling it out on behalf of the thief makes it an act of acquisition. So that's what's being proposed by the Gemara. So they're saying, surely then the shomer would be liable. So the Gemara rejects the proof. Amemar said to him, the Mishnah refers to where the owner gave it to one of the people mentioned in the Mishnah, and the thief stole it from them by pulling it out of their domain. So what it's saying is, Amemar is saying, look, if a creditor took the animal because the original owner owed him money, or somebody borrowed the animal, or there was a renter, or there was a paid guardian, any of those things, a transfer of ownership is not the issue here, because the minute the thief stole it from one of these, agencies or intermediaries, etc., then that thief is responsible completely. But the agent isn't responsible because it was an agreement between the original owner and that agent, whether it's a guardian, paid or unpaid, or a borrower, or whether it's a creditor. So the Gemara gives a counter argument and said, but the Tana already taught this law that a thief becomes liable for the theft only when he pulls the animal out of the owner's domain in the first part of the Mishnah. So why is it that the same law would be taught a second time? So the Gemara answers, in the first part of the Mishnah, he taught the law with respect to a thief who stole it from the house of the owner. And in the second part of the Mishnah, he taught the law with respect to a thief who stole the animal from the house of the shomer, the guardian. So basically, there are two different answers to it. So basically, some of the commentaries say that Tosfot had a difficulty with the Gemara's answer, because that can only be said with respect to where the owner gave it to a shomer, a borrower or renter. But we're saying, hang on a second, we've got an issue. Where the owner gave the animal to a Kohen for the redemption of his firstborn. By the way, Jeff Kaplan was a Kohen like Gavin. That's also what they had in common, not just Trump. Where the owner gave the animal to a Kohen for the redemption of his firstborn son, or to his creditor as a payment, the Kohen and the creditor actually own the animal. The shomer, guys, is a different case because he's either borrowing it, he's renting it, or he's looking after it for the owner's behalf. Therefore, in those three cases of a shomer, three different types of shomer, the shomer isn't responsible for anything other than a temporary looking after the animal. But the Kohen is responsible as it was given to him for the redemption of his firstborn son, the original owner, and a creditor took it as payment. So in that case, the Kohen and the creditor actually own the animal, and therefore the case is exactly the same as the Mishnah's first case, where the thief stole the animal from its original owner, or from the original domain. So Tosfot answers that question, his own question, for our benefit. He asked it and answered it, and says that according to this interpretation of the Mishnah, we've got to say that the Mishnah doesn't refer to where the owner gave it outright to the Kohen or creditor, but rather to where he gave it to them as a security from which they are to collect in the event that he doesn't make payment by a specified future date. Now it makes sense, guys. Does that make sense? So they've got the same legal status as a shomer, a temporary looker after of the animal until that debt is paid. It's not theirs. Otherwise, you're learning the same lesson again and again. Okay. So the Gemara then rejects that particular answer because Rav Ashi said to Amimar, because that was the answer of Amimar, do not reflect the proof in this manner. For what difference does it make whether the thief stole the animal from the house of the shomer or whether the thief stole the animal from the house of the owner? In other words, there's no reason to suggest that the thief's mashicha, in other words, the pulling for the acquisition, should be subject to different rules when he takes an animal from the owner's domain or whether he takes it from the shomer's domain. So there would be no point of the Mishnah to state the second case. Okay? So rather, is it not where the Mishnah is referring to where the shomer pulled it out on instruction of the thief, and thus learn from this that the sages instituted pulling mashicha as a method of acquisition with respect to shomrim? So the Gemara actually concludes, indeed, you need to learn from this. Okay, and in other words, that is the case. We need to learn a different rule, that a shomer actually acquires a responsibility for the animal even though he doesn't have permanent ownership of the animal, because either he's borrowing it, or he's renting it, or he's looking after it for money, the minute he pulls it out of the original owner's domain, he's now liable for looking after that animal in full financial force. So that's what you have to learn from this, in addition to the lesson of the thief. Otherwise, it's just repeating the pattern from the first part of the Mishnah to the second. So the Gemara corroborates that resolution, says it was stated likewise. Rav Elazar said, in the manner that the sages instituted pulling Mashiach as a method of acquisition in the case of purchases. In other words, I'm buying an article from you, I've paid you the money, and I'm pulling it into my domain. Now, that transfer doesn't go through to you. Well, it doesn't go through to me, the buyer, even though like champions, not like
today you got me on the worst day for this.
So Kevin, the reason for this is that the courts, if I bought a car from you, we buy cars, I bought a car from you, and the car's in your premises and I haven't collected it yet, and there's a fire and it burns the car down, you are responsible for refunding me that money according to law. If the acquisition was mine and you have a fire in your place, or you have a theft in your place, you wouldn't have insurance because you said you bought it, it's your problem now. So it's to protect the purchaser, that the refund would have to be given back to the purchaser legally in the event that something happened at the original owner's, at the seller's location of the article. That means that the seller has to look after it until the buyer gets it. Kev, your eyes are closing.
Even though, no, eyes aren't done. It's my glasses.
Oh, okay.
Are you saying because only when the purchaser drives it out of the dealership, then it is basically?
Yes, and the reason being is that the seller must be responsible for looking after it until the purchaser has taken it out of the seller's premises. Otherwise, the seller could just turn around and say, listen, I got your money, there was a fire, there was a theft. So the court is saying no. They will make legally the seller refund the buyer if it's not looked after in pristine condition in the seller's premises. And it only transfers ownership when the buyer's pulled it out of the showroom floor.
Because then the buyer can't claim.
No, it's to protect the buyer, not the seller. Because the seller could say, listen, well, you paid me, but we had a robbery.
So the buyer can't then, once the buyer takes possession, if something happens,
correct.
Unless it's a factory fault, then that it's his responsibility.
Correct, guys. So what we are saying is, Rabbi Elazar said, in the manner that the sages instituted pulling Mashiach as a method of acquisition in the case of purchases, so they instituted pulling as a method of acquisition in the case of shomrim, guardians. And we're saying there it's a borrower, a renter, a paid custodian, and an unpaid custodian. And all of those have got different levels of responsibility. The more of a favor you're doing the person, like the person that's borrowing your car, the more he's responsible. The more of a favor he's doing you, like looking after your place when you have to go overseas in a hurry, the less you can hold him responsible. He's still responsible for certain things, but not the full gamut. And it was also taught in a brisa, just as they instituted pulling as a method of acquisition in cases of purchases, so they instituted pulling as a method of acquisition in cases of shomrim, guardians. And just as land is acquired by means of money, a document, or a proprietary act. Now, a proprietary act is a way to improve the land that you've bought. So, in other words, you've got to you've got to fix the property up in some way, some small action, either plow a little portion of the field, lock a gate, or create an opening in the fence. Either way, when we say money, is the buyer gives the seller some money to acquire the property. When we say a shtar, a document, the owner draws up a bill of sale or a gift stating that he's selling or giving the property defined therein to the buyer or recipient. So by handing the document over to the buyer, the sale is effected without any payment. So all of those three kinyanim methods of acquisition to effect the sale of real property, like actual land, guys, that's in Kedushin in the 26th daf. So as far as that's concerned, the Gemara asks, to the rental of what type of property does the brisa refer? If you say it refers to the rental of movable property, in other words, are then movables fit for acquisition through a document? Because movables are acquired only through mashicha. In other words, like pulling or taking an article, like you buy a cell phone at the shops, you're taking it. If you buy a cow, you're pulling it by the reins. And obviously, granted that money does have somewhat of an effect upon the sale of movables, in that although it doesn't affect actual acquisition, and the parties can technically renege on the deal, guys, because remember we said that it doesn't become the buyer's until he takes it out of his premises, because the seller might not look after it properly. Or either one can pull out of the deal because one didn't fulfill their obligation, either the buyer or the seller. The money is somewhat of an acquisition, but the reneging party must accept upon himself a shepara, which is a formal censure administered by the court to the party that says he does not keep his word and retracts from the sale of movables after the buyer gave money prior to performing mashicha. So in other words, it's not just a thing where the seller can say, I've changed my mind. He's got to go to court. He's got this process that's administered by the court, and they let him know he never kept his word, and it's not so straightforward. So that's in the 44th daf of Bava Kamma. So, but a document, however, has no effect upon the sale of movables at all. So, for where there are only words but no money passed between the buyer and seller, it's permitted for either party to renege. Okay? So when money occurs, there is somewhat of an agreement. It can be seen as a proof of payment. But acquisition is what is a transfer of ownership. That's actually the case. So the Gemara answers, Rav Chisda said, the Brisa speaks of a rental of land. In other words, the Brisa teaches that when, for example, a house is rented, the agreement is consummated and cannot be rescinded by either party. So in other words, once the renter tenders money, in other words, he pays for the rent of August and he pays a deposit, or the owner transfers to the renter a document stating my house is rented to you, these are the specs, etc. Or C, the renter performs a proprietary act to improve the property he's renting in some way. So that's those are the three ways. Those are the three ways to do it. But you can't acquire a movable through a document. So Rav Chisda is saying here, if there's a document involved, it must be speaking about rental of land. It doesn't have to go as far as buying land, but it's obviously a significant amount of money. All right, guys, we're done. I hope you have a good evening.
Yeah, tomorrow, what can we have the share just a little bit earlier? Because I got a friend of mine's party.
Yes, it must be by mincha time for Jeff. What about 4:30?
4:30. Let me just. Is it okay for Arthur and Gavin?
Yeah, we could do it. We can do it at 4:30, 4:20. What do you want, guys? 4:20. So you can do mincha, Gavin.
Yeah. 4:20 is better.
4:20.
That's great for me. Yeah, that's. I think
we'll be done by.
Actually, no, that's. Actually, I think I put it at. I think we could do it another time anyway. For some reason, I put it in my calendar. Yes, because
we could get a double session for Jeff.
Yes, you mean double meeting tonight and tomorrow during the day still? Oh no, of course, absolutely. Thanks,
right.
man.
4:20,
guys. Thanks.
Looking forward. Shkar.
Thanks a lot. Have a good night, guys. Thank you.
Yes.